Employment Discrimination Prevention in Maryland. The Maryland Commission on Civil Rights, or MCCR, represents the interest of the state to ensure equal opportunity for all through enforcement of Titles 20 of the State Government Article and 19 of the State Procurement and Finance Article, Annotated Code of Maryland. MCCR investigates complaints of discrimination in employment, housing, public accommodations, and the state's commercial non-discrimination policy from members of protected classes that are covered under these laws. What is a protected class? Every Marylander is guaranteed equal opportunity in employment and in all labor management union relations, regardless of race, color, religion, ancestry or national origin, sex, age, marital status, sexual orientation, gender identity, disability, or genetic information. Employment discrimination. What is discrimination? To discriminate against someone means to treat that person differently or less favorably than others. In Maryland, it is illegal to discriminate against an employee based upon their protected class. In this section, we will review common forms of illegal employment discrimination. Disparate treatment. Disparate treatment refers to intentional discrimination, where people in a protected class are deliberately treated differently. This is the most common type of employment discrimination. An example would be an employer giving a certain test to all of the women who apply for a job, but to none of the men. When analyzing a complaint of discrimination alleging disparate treatment, an investigator may assess the following information: whether the complainant is a member of a protected class, whether the complainant was treated differently from similarly situated employees not in their protected class. To assess whether comparable employees are similarly situated, the investigator may evaluate whether the comparators reported to the same chain of management or performed duties similar to those of the complainant. In the absence of comparative evidence, the investigator may look for other evidence that indicates that the employer's actions may have been motivated by discrimination, such as direct evidence. Next, the investigator will review the employer's response to the charge of discrimination. A potential final step for the investigator could be an analysis of whether there is pretext, meaning any evidence that the employer's stated reason for its conduct is false. Disparate impact. Disparate impact occurs when policies, practices, rules, or other systems that appear to be neutral result in a disproportionate impact on a protected group. For example, a grooming policy that indicates that customer service associates may not wear beards could unintentionally discriminate against employees whose religious beliefs do not permit the shaving of facial hair. Disparate treatment and disparate impact may seem similar, but they are different. For example, if only African American applicants are required to take a pre-employment assessment test, that could be disparate treatment. If an employer tests all applicants and only African Americans are eliminated based on the results of the assessment, that test and the testing requirement could have a disparate impact. There may be instances in which the terms and conditions of employment may present as discriminatory, but fall outside the scope of the aforementioned protections. For example, say a paramedic service employer required job applicants to carry a heavy load up several flights of stairs, and a higher percentage of male applicants pass the test compared to the number of female applicants who pass. In that case, the test could have a disparate impact on women, who are a protected class. But if the paramedic service can show that carrying heavy loads upstairs is a necessary part of the job, then the test may be legal, even if results lead to more men qualifying than women. But say a human resources firm gave job applicants the same test, requiring them to carry heavy weights up a flight of stairs. In this case, the resulting disparate impact discrimination may be illegal, unless the employer can provide a legitimate job-related reason why an HR professional would need to carry heavy weights up a flight of stairs. This job requirement may have an illegal disparate impact on female applicants. Harassment. Harassment is unwelcome conduct that is based on a protected class. In general, harassment becomes unlawful where enduring the offensive conduct becomes a condition of continued employment. Or 2, the conduct is severe or pervasive enough to create a work environment that a reasonable person would consider intimidating, hostile, or abusive. Maryland's anti-discrimination laws also prohibit harassment against individuals in retaliation for filing a discrimination charge, testifying, or participating in any way in an investigation, proceeding, or lawsuit under these laws, or opposing employment practices that they reasonably believe discriminate against individuals in violation of these laws. Petty slights, annoyances, and isolated incidents, unless extremely serious, will not rise to the level of illegality. To be unlawful, the conduct must create a work environment that would be intimidating, hostile, or offensive to reasonable people. Offensive conduct may include, but is not limited to, offensive jokes, slurs, epithets or name-calling, physical assaults or threats, intimidation, ridicule or mockery, insults or put-downs, offensive objects or pictures, and interference with work performance. Harassment can occur in a variety of circumstances, including but not limited to the following. The harasser can be the victim's supervisor, a supervisor in another area, an agent of the employer, a coworker, or a non-employee. The victim does not have to be the person harassed, but can be anyone affected by the offensive conduct. Unlawful harassment may occur without economic injury to or discharge of the victim. Reasonable accommodations. In general, a reasonable accommodation is any change in the work environment, application process, or in the way things are customarily done that enables an individual with a disability to enjoy equal employment opportunities. Examples of reasonable accommodations may include job restructuring, such as altering when and or how an essential function of a job is performed, modifying work schedules, acquiring or modifying equipment or devices, such as adjusting a desk height to accommodate an employee who uses a wheelchair, adjusting or modifying tests and training materials, for example, providing materials in alternate formats, such as Braille or large print, providing assistive technology or devices, such as computer screen readers, for employees with visual impairments. reassigning an employee with a disability to a vacant position for which he or she is qualified when no longer able to perform the essential functions of the current job, with or without reasonable accommodations. When analyzing a complaint of discrimination based on denial of a reasonable accommodation, an investigator may assess the following information. Does the complainant have a physical or mental impairment? For example, deafness, blindness, mobility impairments requiring the use of a wheelchair, intellectual disability, autism, cerebral palsy, major depressive disorder, bipolar disorder, post-traumatic stress disorder, obsessive-compulsive disorder, schizophrenia, cancer, diabetes, epilepsy, HIV infection, multiple sclerosis or muscular dystrophy that is readily observable or medically documented? Does this impairment substantially limit the complainant's ability to perform a major life activity? For example, caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, and working. At the time of the alleged incidents, did the employer know of the complainant's disability? Is the complainant otherwise qualified for the position? That is, does the complainant, with or without accommodation, meet the education, skills, and experience requirements of the job? What are the essential functions, things a person holding the job absolutely must be able to do, of the complainant's job? Did the complainant request an accommodation? What accommodation, if any, did the complainant suggest? What action did the agency take to identify possible accommodations or attempt to accommodate the requesting employee? Did the agency provide an accommodation? If an accommodation has been identified, is it effective? If the employer did not provide an accommodation, what reason has the employer given for its refusal? Religious accommodations. Another form of accommodation request involves sincerely held religious beliefs. Employees may request to be accommodated in order to observe or follow the practices of their religion. Religious beliefs includes theistic beliefs, i.e., those that include a belief in God, as well as non-theistic moral or ethical beliefs about right and wrong that are sincerely held with the strength of traditional religious views. A religious accommodation is any adjustment to the work environment that will allow an employee or applicant to practice his or her religion. The need for religious accommodation may arise where an individual's religious beliefs, observances, or practices conflict with a specific task or requirement of the position or an application process. Accommodation requests often relate to work schedules, dress and grooming, or religious expression in the workplace. If it would not impose an undue hardship, the employer must grant the accommodation. In requesting an accommodation, whether on the basis of disability or religion, an employee or applicant is not required to use magic words, such as indicating that he or she is seeking an accommodation. However, an employee or applicant must make the agency aware of the need for an accommodation. Retaliation. Retaliation occurs when an employer takes an adverse action, for example, discipline, termination, demotion, or reassignment, against an employee for engaging in or exercising their rights that are protected under the law, also called protected activity. Examples of protected activities are refusing to commit illegal acts of discrimination despite your employer's direction or request, filing a claim against your employer with MCCR or the EEOC, complaining to your employer about workplace discrimination or harassment, participating as a witness in an MCCR, EEOC, or internal workplace discrimination investigation. When analyzing a complaint of discrimination based on retaliation, an investigator may assess the following information. Did the complainant engage in protected activity or oppose unlawful discrimination? Was the employer aware, or should the employer have been aware, of complainant's protected activity? Was the complainant subjected to an adverse employment action? Does a connection exist between the complainant's protected activity and the adverse employment action? For example, an employee is terminated shortly after filing a complaint of discrimination. Remember, all complaints of discrimination are assessed on a case-by-case basis. The first step to filing a complaint is to initiate an online inquiry using the form on our website, mccr.maryland.gov. You may also contact us by phone, 800-637-6247 or 410-767-8600, Maryland Relay 711. Intake. The intake unit will contact you to schedule an interview, either by phone or in person, with one of our trained intake officers to complete the process. You must complete the interview and sign and return any and all necessary documents, including the charge of discrimination, to the Maryland Commission on Civil Rights before the complaint is officially filed. Charge investigation. Once a case is assigned for investigation, the investigator will conduct an impartial investigation to determine the facts through interviewing witnesses, gathering and analyzing documents, conducting on-site visits, and conducting fact-finding conferences. Voluntary resolution. MCCR offers parties many opportunities to resolve charges of discrimination. Successfully resolving the case through one of these voluntary processes is often expedient and beneficial for both parties. Methods of resolution include settlement and conciliation. Issuance of written findings. After completing an investigation, the investigator will draft a written finding, which will clearly state the positions of the complainant and respondent relative to the allegations made in the complaint and identify the results of the investigation. Finding of probable cause. If the investigator finds that based on the gathered evidence, it appears that there is probable cause to believe that the complainant was discriminated against, the investigator will take the necessary steps to resolve the matter. MCCR staff is responsible for making a good faith effort to conciliate these matters. Conciliation efforts focus on bringing the discriminatory practice or policy into compliance with the law and providing full remedy and relief for the complainant. However, if conciliatory efforts fail, the case will be forwarded to the Commission's Office of the General Counsel. Finding of no probable cause. If the investigator finds that based on the submitted evidence that there is no probable cause to believe that the complainant was discriminated against, a written finding of no probable cause will be issued, and the case will be subsequently dismissed. The complainant then will have 15 days to file a written request for reconsideration to the Commission's Deputy Director. Once the Deputy Director has reviewed the complainant's request, a decision will be made to either uphold the finding issued by the investigator or remand the case back to the investigator for further investigation. Education and outreach. The Maryland Commission on Civil Rights provides outreach services, information, and training support to agencies and individuals in Maryland on issues affecting equal access and opportunity. Through our community outreach and education program, we offer workshops and seminars to institutions, businesses, and organizations throughout the state. Thank you. We look forward to working with you to accomplish our vision to have a state that is free from any trace of unlawful discrimination.